let's get to a couple of questions. Jennifer Riley, we'll start with you. In light of the U.S. Supreme Court ruling in the Epic Systems case, are workplace class actions headed for the sunset?
Well, that is an excellent question. And the answer is, I don't think so. There's still a lot of money on the table, if you will, in terms of ways to bring these claims that are going to motivate the plaintiffs' bar to continue to bring these claims. We've seen workarounds. It's starting to become apparent in terms of how they're going to go about bringing these claims in light of the move toward arbitration agreements. One of them I mentioned briefly is the PAGA trend. That's the Private Attorney General's Act type cases where the California Supreme Court, for instance, has held that they are not subject to individual arbitration agreements because the state of California is a party, and therefore the state is not bound, and the plaintiff is really standing in the shoes of the state. So that's one way. That is one type of a workaround. Another is, bringing a collective action, getting hold of a notice list prior to having the arbitration fight, because once the plaintiff's bar gets a hold of the notice list, they have a potential way to identify a lot of people who can bring individual arbitration. So I'd say the second workaround I've seen is a mass move toward individual arbitrations, but filing hundreds of them at the same time. The filing fees alone can add up to hundreds of thousands and millions of dollars just to get the individual arbitrations off the ground if brought in a mass way. So that's another workaround. There are going to continue to be others, I'm sure. One of them, or another one, I should say, is the legislative attempt to get around EPIC. I mean, we saw Justice Ginsburg call for a legislative answer in her EPIC dissent, and there's been some action on the congressional level to look at making these class action waivers, these mandatory arbitration agreements, just not something that is going to be a way to handle workplace issues going forward. It probably depends on who is elected to the White House in the next term to see whether those really are going to gain enough traction to become the law of the land. So stay tuned on that front.
One other note, I was listening to something in a podcast recently, and it raised an interesting question, which is, are non-disclosure agreements a good idea in terms of cutting down on the size of the class by negotiating settlements and then putting in place NDAs?
Negotiating, well, if you negotiate a settlement on a class or collective level, or a class level.
What I'm getting is you negotiate with individual people.
Yep.
So you cut down the size of the class. Are those people now prohibited from being called and providing evidence because they've signed an NDA with a company?
Yeah, I see where you're going. Yeah, I mean, that's one potential way to sort of cut them off at the beginning, reach an individual settlement with the person bringing the lawsuit. So settle off with the main plaintiff before litigation is even filed or after litigation is filed, and settle in a way that the settlement is going to remain confidential. That's certainly one way to deal with it, to cut it off if you can find a willing participant on the other side. The downside, however, is that you get what you pay for, or in this case, maybe you get less than you pay for because you're paying a premium to get rid of the suit at the outset, but you're only getting released by that individual who you're settling with. So you may buy yourself peace, but your peace may be short-lived.
Dr. Bierhensel, what are the biggest surprises employers can expect to get if they bring someone in and have them do a detailed analysis of their employment data?
Well, I'll throw it back to the very last item that I talked about, and that is, what employers think they know that just isn't so. The most common thing we see is employers who, because they have very good policies and they have managers they trust to implement them properly, that they're certain that they don't have any issues with pay equity, for example. And what we often find is, we'll come back to them and say, well, actually, we've looked at employees in the same job or similar jobs, and we see that there's a pay equity issue. And employers say, well, I don't understand how that happened. We promote men and women at the same rate, and we give everyone the same types of pay increases. So how do we end up with a pay equity problem? And oftentimes what happens is it goes all the way back to starting salary, where they've hired men in at a higher salary than women. And while promotions look great and raises look great, what it ends up doing is simply taking that initial pay disparity and just sort of perpetuating it along through the years. And of course, there's always reasons for that, but having, as employers and as Jennifer knows, having to explain the legitimate non-discriminatory reason for why a pay disparity exists is not as good as not having a pay disparity that you have to explain at all. So that's what we often see. Employers can be overconfident about how good they look when someone goes in, and particularly in the case of litigation or a regulatory investigation, it's an unfriendly party going to come in and look at their data, and they'll decide what story it's telling, rather than employers getting out front, digging in and seeing what's there initially, and then either taking steps to correct it or taking steps to address it.